Hi everyone. As I came up with the last video regarding the 106th constitutional amendment, in which I mentioned that there will be videos upcoming regarding the latest legal current affairs. So here comes the second video regarding the amendments which were brought during the monsoon session of the parliament. Different acts have been amended and a new legislation regarding data protection has also been introduced during this session. So in this video, in this lecture, I'm going to discuss all the important aspects of this new law, which was actually the need of the hour, and few other legislations in which the necessary amendments were proposed and they were passed. Starting with the Digital Personal Data Protection Act 2023. So a need was felt for a proper law regarding the protection of data, and this was actually answered in the form of Digital Personal Data Protection Act 2023. It has been a long journey and it has also taken time to actually get into force or to come into picture regarding the protection of data. Data is considered as the new oil of the 21st century. That is so important. It is so essential. Hence, there was a need for this law. There were certain reasons behind, or we can say there were certain things which acted uh, in consonance, or which actually became a reason for this for the bringing of Digital Personal Data Protection Act. Firstly, there was a case of Justice K.S. Puttaswamy, retired, versus Union of India 2017. This was a nine-judge Supreme Court decision in which the court unanimously held that there is a fundamental right to privacy which has been given to all the citizens, all the persons who are all the Indians basically. And this right is an intrinsic part of right to life and liberty under Article 21. So there was a basically this there was a recognition of the right to privacy, and right to privacy includes the personal data of a particular individual. In furtherance with the decision of Justice K.S. Puttaswamy, the government of India, it formulated a committee which was headed by Honorable Justice B.N. Shri Krishna, who gave its recommendations in the form of a report in 2018, wherein it stated that there is a need to strengthen the privacy law in India by laying down restrictions on processing and collection of data. So here also data comes into picture, forming data protection authority and recognition of right to be forgotten, and there were certain other aspects which were actually recommended by this committee. So this became the second reason. And the last but not the least, Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. In this, there was these rules, they actually mandated social media platforms to exercise greater diligence with respect to the contents on their platform. This was because there was a need, and there was a need and there was a recognition that right to privacy must be that privacy must be protected, that right must be protected at all costs. Moving further with the important provisions of this act, uh, firstly the applicability, why this, or what are the things on which this act would be applicable. So it will be applicable on the processing of personal data. Now this processing can be within India or it can be outside India. Within India, where such data is collected online, or where it is collected offline but it is digitized. Outside India, only on those aspects or only those data which has been collected for purpose of offering goods and services in India, only on such data this act would be applicable. There are now there are certain important terms which comes into picture along with the reading of this data. There are these important provisions you must be aware of. Like the first and the foremost is personal data. So personal data is anything which is related to an individual, and it helps to identify that person in relation to such data. Has been defined. The section numbers I have provided. This is not the exact definition, but you will get an idea about what personal data refers to. Second is processing. Now, processing of personal data, this act is applicable on processing of personal data. So it implies, processing implies collection, storage, use, and sharing of data. There are certain other processes also which are included in processing of data, but this is the general meaning of this term processing. Person here includes both natural as well as the artificial juristic person. So data of a natural person as well as of a company, of a association of persons, or any other artificial juristic person who has been recognized by law as a person would be covered by this act. That person's data would be protected by this act. Data principal, that is the individual whose data is being processed, and data fiduciary is the person or the entity which actually determines the purpose and the means of processing such data. Moving on with the important aspects of this legislation, of this act, there are certain important aspects which I have discussed under different heads, starting with consent. See, personal data may be processed only for lawful purpose. This is important after obtaining the consent of the individual, only after obtaining the consent. Secondly, this consent may be withdrawn at any point of time. So there is no requirement that no obligation upon a data principal that he has to give his information for a particular period of time. It can be withdrawn at any period and at any point, and after that his data needs to be removed by the data fiduciary from his records. For individuals who are below 18 years, consent will be provided by the parent or the guardian. And there's an exception to this consent, to this general rule, that any data can be processed only for after obtaining the consent of the individual. If there is an exception to this rule, and that exception is that it is not required for legitimate uses. What are the legitimate uses? Some of the legitimate uses are: specified purpose for which data has been provided by an individual voluntarily, first. Second, provision for benefit or service which has been provided by the government. Third is the medical emergency or for the employment purposes. So these are the legitimate uses in which the consent of the individual is not necessary for recording the data. Second important aspect is regarding the rights and duties of data principle. See, you need to remember this point, that with the right there comes certain duties as well. So not only rights have been provided for the data principal or for any individual whose data is going to be being processed, there are also certain duties which have been imposed upon him. Starting with the rights, first right which a data or the sorry the data principal has is that he can obtain information about processing, about how the processing is being done, for how much period the data would be processed. Second is that he may seek correction and erasure of personal data. Third is that he may nominate another person to exercise his rights in event of his death or incapacity. In case the data individual or the data principal, he dies, or he becomes incapacitated in any manner, whether physical or mental, in that case some other person who has been nominated can give consent for the collection of the data of such individual or such data principal. Then there is also a mechanism for grievance redressal. Data principal has certain duties. First duty is that he should not register, he must not register any false or frivolous complaint. And second is that he must not furnish any false particulars or impersonate some other person. He must not impersonate some another person. He must give details only of himself, not of some other person. And in case he violates any of these duties, he shall be punishable with a penalty which may amount up to rupees 10,000. Obligation of data fiduciaries. A data fiduciary is under an obligation. Now data fiduciary, as I explained before, that is the entity which is going to use the data. So the means and the purpose for which the data is going to be being used, that is determined by the data fiduciary. He has certain obligations with regard to the data which he is collecting and the data principle of whose data he is collecting. First is that he must make reasonable efforts to ensure accuracy and completeness of data. Second, he must build reasonable security safeguards to prevent data breach. Third is that he must inform Data Protection Board of India and affected persons in event of breach, and he should erase any data which has met the purpose for which it was recorded until and unless its retention is not necessary for legal purpose. So that is a storage limitation. There are two kinds of limitations which you must which may come into picture while reading about the data protection laws. One is storage limitation, other is purpose limitation. Storage limitation is with regard to the time period for which data can be stored, and while purpose limitation is the purpose for which it can be stored. Exemptions, there are certain exemptions, basically those circumstances on which these rights and duties where these rights and duties would not apply. First is the prevention and investigation of offences. Second is enforcement of legal rights or claims. Central government may by notification exempt certain activities from application of the bill, जैसे कि processing by government entities in interest of security of state and public order, and second purpose may be for research archiving or for statistical purposes. These are the few exemptions on which the exemptions, that is on those circumstances on which in which this act would not apply. Data Protection Board of India, there are certain, now this authority has been formed under this act, and there are certain key functions of this board. So what are the functions of this board? It has to monitor compliance and impose penalties in cases of breach. Second, it may direct the data fiduciaries to take necessary measures in event of data breach. And third is that it has this authority to hear grievance regarding any breach of data by the data fiduciary. So any grievance, this grievance redressal of the data principle will be heard by the Data Protection Board of India. So term of the board members is 2 years and members are eligible for appointment. The last and the important aspect of this legislation is the penalties. Rupees 200 crores for non-fulfillment of obligations for children, that is in case of data breach which is related to a person who is less than 18 years, up to rupees 200 crores can be imposed as a penalty, and rupees 250 crores for failure to take appropriate security measures to prevent data breaches. But see, there are certain issues still with this legislation, which includes first that exemptions of the state may have implications on the right to privacy. Secondly, that overriding consent for the purpose of such as benefit, subsidy, license and certificates, it removes one of the limitations, that is the purpose limitation. So here consent is not required in these circumstances, as I have explained or told in the consent head, the consent important aspect. It does not regulate harm arising from processing of personal data. So your harm implies mental injury, some stress or financial loss caused due to the processing of such data, theft, reputational loss, discriminatory treatment, etc. All this is not covered under this act. Right to be forgotten is also not provided as one of the provisions, which was recognized under Zorawar Singh versus Union of India by 2021 as one of the rights of the citizens. Moving forward with the next amendment which took place was in the Act of Forest Conservation Act, Amendment Act 2023. It basically brought an amendment regarding the application of the Forest Conservation Act. So it exempts the application of the act on the land within 100 kilometers of India's borders from purview of conservation laws, and permits setting up of zoos, safaris and ecotourism facilities in forest areas. So here Forest Conservation Act would not apply. It also exempted forest land included forest land, which includes land located within 100 kilometers of international borders like LOC, LSC, and these lands or these border areas would be used for the purposes of construction and for strategic purposes. Basically, from defense perspective, if some land is required in around the international borders, that would be exempted from the Forest Conservation Act. The Press and Registration of Periodicals Act 2023. This is a new legislation which is meant to replace the old Act of 1867. The purpose of this act is to actually govern the print and the publishing industry. So two three main points here are that here press registrar general has a suo motu power to cancel or suspend registration. Earlier he didn't have this power. Earlier only DM has had the power to cancel or suspend the registration. Further, if any person who is convicted by the court for an offense involving terrorist act or unlawful activity for something which he has done against the security of the state, he shall not be permitted, he shall not be given license for bringing out any periodical at any further time or any further period. Government of NCT of Delhi Amendment Act 2023. Here there was this judgment of Supreme Court in in March 2023, after which the government of India it brought a bill, an ordinance actually in May 2023 regarding the powers of how to control the postings, transfers, the if any disciplinary proceedings have to be taken against the officers of central government who are serving in government of NCT of Delhi. In that case, what all has to be done, who has this authority, the Delhi government, the Delhi state government, or the lieutenant governor, whose lieutenant governor whose decision would be considered as the deciding factor or as the as final. Those cases were those circumstances were actually laid down in the ordinance, and the government brought this bill which resulted into the act after receiving the assent of the president, which seeks to dilute the powers of Delhi government over these services. National Sea Services is a subject which is just give me a second. So this services subject is provided under the 7th schedule, wherein the state has this power to control the officers who are serving in the state under state public service commissions. So here the officers who were serving were of the central government, and they were serving in the national capital territory of Delhi, now which comes within the purview of the Delhi government, Delhi state government. So here the question was, the issue was that who has the power to actually decide upon the matters relating to such officers. National Capital Services Authority was established through this act, which shall make recommendations to Lieutenant Governor regarding transfers, postings, etc. of all Group A officers serving in the affairs of government of NCT of Delhi. So here LG's decision was made final by this Amendment Act. So coming into an end with this, the lecture is completed, and this includes all the important legislations, all the important current affairs regarding the new amendments and the act, the very important act which was brought during the monsoon session of the parliament. Thank you.